Claude, or ChatGPT, for lawyers in 2026. It is the question every practitioner I know has typed into a search bar at least once this year. And the answers out there are mostly written by people selling something. So we are going to do this differently. This channel is advised by a panel of senior practitioners with decades of combined experience across contract, construction, commercial litigation, employment and industrial law, taxation, and government administration. They use both tools every day on real legal work, and the panel has a clear preference. By the end of this episode, you will know what they actually reach for and why. This is not a feature list, it is a verdict. Before we start, 3 things actually matter for legal work. Not benchmarks, not vibes. 1. Context window. How much of a brief, a file, a contract bundle the model can read at once. Not how much you paste in, how much it actually holds in working memory. 2. Instruction following. Whether it does what you asked in the order you asked all the way through to the end of the request. Most demos show step 1. Real legal work is steps 1 through 11. 3. Behavior when wrong. What the model does when it doesn't know. This is the one almost every comparison ignores, and it is the one that decides whether you can trust the tool with anything that matters. We are running 4 rounds against those 3 properties. Round 1. Long documents. Claude's context window is roughly 1 million tokens. That is around 750,000 words. ChatGPT's flagship sits at 200,000 tokens, somewhere near 150,000 words. In practice, that gap is the difference between AI being useful and AI being theater. Picture a 400-page construction delay claim. Daily site reports going back 14 months. 14 variation orders. 3 expert witness statements running 90 pages each. The kind of file you would normally hand to a junior to spend a week summarizing. Claude reads the whole thing in a single pass and answers questions about it as if it has lived with the file all week. ChatGPT chunks the file, summarizes by section, and quietly forgets what was in part 1 by the time you ask about part 4. For anyone working with discovery bundles, due diligence rooms, large transactional packs, regulatory filings, this is the round that decides the fight before the others even start. Verdict. Claude, decisively. Round 2. Drafting voice. Same prompt to both models. A short letter to a corporate client advising that a proposed indemnity is acceptable subject to 2 qualifications. Claude returns. Following our review of the documents you provided, we are of the view that the proposed indemnity is acceptable, subject to 2 qualifications set out below. Careful, hedged, precise. Sometimes, particularly for a startup founder or a sophisticated commercial client, too formal. ChatGPT returns. We've taken a look at what you sent through. The indemnity should work for you, with 2 small tweaks that we'll walk through below. Warmer, looser, more like a senior associate writing a note rather than a partner signing off on one. Sometimes, particularly in front of a regulator or opposing counsel, too casual. If you are writing for an institutional reader, Claude wins. If you are writing for a human reader who needs to feel reassured, ChatGPT wins. The panel uses ChatGPT here more than they expected to. Verdict. ChatGPT, specifically for client-facing voice. Round 3. Multi-step instructions. This one matters more than people think. Most real legal work is a chain of subtasks, not a single question. The test prompt. Extract every indemnity clause from a supply agreement. Compare each one against an internal playbook, flag the 3 biggest commercial risks, then draft a markup in the firm's house voice. 4 steps, sequential, each one depending on the last. Claude holds the chain. It works through each step in order, refers back to the playbook on step 2, ranks the risks on step 3, and produces a clean markup on step 4 with the right tone. ChatGPT typically gets to step 3 and starts summarizing rather than executing. It will tell you what it would do instead of doing it. By the time you reach step 4, you are prompting twice more to recover the thread. This is the difference between a tool that works alongside you and a tool you have to babysit. Verdict: Claude. Round 4. Hallucinations. Both models fabricate. Anyone who tells you their preferred tool does not invent citations is selling you something. The real question is how each model behaves when it doesn't know. Claude will sometimes invent a case name. More often, it hedges. It says it isn't sure. It asks a follow-up question. It tells you what it can verify and what it can't. ChatGPT will sometimes invent a case name. More often, it delivers the answer with the same confidence whether the citation is real or imagined. It asks fewer questions back. Here is the sentence that matters. How a model behaves when it doesn't know matters more than which one fabricates less often. For lawyers, calibrated uncertainty is more valuable than confident wrongness. A model that flags its own doubt is a model you can use on work that gets filed. A model that delivers confident output regardless is a model that, sooner or later, ends up in a sanctions order. We have already seen those orders. We will see more. One more thing. One of the senior practitioners who advises this channel had her legal content role displaced by Claude within a week. She watched the work she had been doing for years be done in minutes by the same tool she is now teaching you to use. And rather than fight the tide, she chose to learn the tool that took her job. This is why she chose Claude. The practitioner's stack. Claude as primary. For long document review, contract drafting and markup, multi-step workflows, statutory analysis, construction claim files, employment policy review, in-house playbook work, and privileged research where careful hedging matters more than confident answers. Which is most legal work, most days. ChatGPT as supplement. For client-facing voice, brainstorming, and anything image-heavy or multimodal. After 2 years of daily use across multiple practice areas, this is the split that holds. Not because Claude is perfect, it isn't, but because for the work that actually fills a practicing lawyer's day, Claude does it better, longer, and with more honest uncertainty than its main rival. Fair's fair. 3 specific situations where she still reaches for ChatGPT before Claude. 1. A warm client email when the firm voice has gone too stiff and the message needs to land like a human wrote it. 2. Brainstorming. ChatGPT is broader, looser, faster than Claude when the goal is ideas, not answers. Naming a new practice group, drafting 20 subject line options, sketching 3 different ways to frame an argument. 3. Anything image heavy. Multimodal still feels stronger on the ChatGPT side, particularly for diagrams, charts, and screenshots of documents. Different tools for different jobs. Anyone telling you to pick one and never touch the other is doing it wrong. Whether you do contract work, construction disputes, litigation, employment and industrial law, tax, government administration, or in-house counsel, there is an episode coming for you. Drop yours in the comments and we will move it up the queue. And if you want the rest of the series as it lands, subscribe. That's the episode. See you in the next one.